we try to maintain that context as we're discussing things with the principals of the business, to have in mind that these third-party family members, and the best policy is to avoid the issue by getting it out there as early as possible. When we're engaged in a transaction to exit a business or to be acquired by someone and continue in the business, oftentimes we'll immediately go to Trust and Estates Counsel to participate in that conversation even before we get through the acquisition phase, because often for clients the critical thing is, how does this fit into my family's long-term plan? How is this going to benefit my kids and my grandchildren? How am I going to ensure that through this acquisition agreement, where I'm selling my business that I've spent a decade or more developing, that I'm going to ensure that they're covered and protected no matter what happens after acquisition.
Just with regard to corporations and running businesses, if there are adult children who are involved versus how does that work when there are some adult children who are not, maybe still profiting off of the business by being part of the family?
That's among the most complicated situations that we see, and it happens more often than you'd think, or maybe exactly as often as you'd think. So often we'll have one child or multiple children that are learning the family business and growing up through it, and others who have decided to opt out and they are running their own careers and they're not dependent on the business for their day-to-day livelihood. But they have an inheritance share, so to speak, in the long-term growth and development of the business. And so there are moments when there are decisions within the business that are going to impact more than just the people who operate the business and the employees, but also the stakeholders of the next generation. So the key thing is to include those people in those conversations as early and as often as possible. And we try to maintain that context as we're discussing things with the principals of the business, to have in mind that these third-party family members, and the best policy is to avoid the issue by getting it out there as early as possible. So when it comes to estate planning and you're thinking about a situation like this where you have a principal and maybe the next generation is also involved in running the business, and on the business side that's a clear succession, but how do we plan for this from an estate planning standpoint to make sure that everybody's covered?
Sure. So sometimes we'll see the family member who's running the business making provisions in their wills and trusts that will take account of the fact that when my business sells, X and Y will get shares as being part of the succession plan, and just with regard to the corporate, how it's sold, and then making provisions for other family members, so potentially leaving them more assets in other ways. And sometimes what helps is being completely transparent, and we'll write provisions in their wills and trusts that say, I love my daughter, but I'm leaving her this amount instead of, but I'm leaving my son out a little bit more, just because he was involved in the business and he's getting assets from other places. And oftentimes just putting it in writing helps, because
what the intentions are
right,
of the drafting
exactly
part.
Yeah. And then because once someone passes away, you can't necessarily have that conversation anymore, or you can't not necessarily, you cannot no longer.
Speak for yourself.
Right, I know. I mean,
I have those conversations all the time.
I know, but sometimes it doesn't get through all the way. So it's better to lay it out.
It's
obviously
always to my benefit, by the way.
Of course.
As a beneficiary.
Right.
To be clear.
And just being upfront, so that when they see it on paper, they don't feel like, oh, I always knew they liked her better. So, and then that does happen. So we do sometimes draft that language in there, just saying this was my intention.
Let me ask you this. Okay, so let's say that at the time of drafting, the value of a business is $10 million.
Mm-hmm.
and the intention is to give equal assets to multiple children.
Right.
So you're finding assets in other areas of the estate
Mm-hmm.
to gift to
Sure.
to other siblings. But then 20 years down the road, 50 years down the road, that business is now worth significantly more or
Right.
significantly less,
Mhm.
and the assets don't align anymore.
Right.
Are there ways to ensure that there's an equitable division
Mhm.
at that time?
Yes, without getting too into the weeds, we include draft language that will say the fair market value of the business at the time of my death or at the time of sale. So definitely trying to think of all the different scenarios that could happen, whether a worst case scenario, in your scenario, the business did better. Sometimes it will do worse, right? So different things, just thinking, I'm always fun to have at parties because I always think of like the worst case scenario that could happen if kids are on a trampoline or something, but thinking ahead in this situation at least benefits professionally of that, and then trying to address it. And obviously, as long as the person is still alive, they can redo their estate planning.
Yeah, so I mean, when someone's exiting a business, which is, you know, a big life event,
Mhm.
that we're involved as a corporate team in that, and maximizing the tax, you know, advantage that they might have, and trying to align the nature of the exit with their life goals.
Right.
We're going to engage trust and estates counsel in order to do that.
Mhm.
But we, as a corporate team, that's basically one and done when it's a big life event like an exit. And then, you know, the trigger, more than life events, is it, you know, the ebbs and flows of someone's fortune
Mhm.
might have nothing to do with the birth or death or exit or acquisition of
Sure.
a business interest. How often would you recommend that someone revisit their estate plan based on their circumstances?
When I'm talking to clients and they're having a hard time, sometimes they have young kids and they're having a hard time conceptualizing that child stepping into a role of executor or agent for them, and I try to back down and say, let's look at, just think 3 to 5 years out, because you can't think about you can't possibly think of a 3-year-old as being 18. And what the ramifications along that line. So I usually just say, let's, you know, to back us down, to calm it down, we can plan, let's think about 3 to 5 years out, and then as circumstances change, let's address it. So I'd say, you know, I think that's the sweet spot, is 3 to 5 years, unless there's other things that happen within the family. Ideally, it would be great if someone pulled it out once a year and looked at it, but I know that's not going to happen. I think 3 years is a little bit more doable and realistic.
So like on your birthday every year, if you go around your house with a video camera for insurance purposes to catalog all your stuff, it
Right.
might be a good idea also to pull out the estate planning documents.
Yes.
I've never once done that, but
Nor
I've
have
heard
I.
I've heard that people do that.
They do, and whenever something drastic happens, especially, you know, with the fires in LA, and I think a lot of people kind of trickled across to the East Coast, where they thought, oh my goodness, if something happened, I have some receipts online, but I don't have pictures or anything. So I think, unfortunately, there might be a silver lining, only in that it gets other people, not necessarily impacted, prepared. So
Right.
you're right, but I don't know.
One person's tragedy is another person's impetus to act. Right.
Sure. I mean, it is, right?
Yeah.
Or can learn from others' mistakes in a, but yeah. So you're right. When someone's going around their house with reviewing their insurance policies and whatnot, yeah,